Hello everyone, we're going to be making a start now for one of our Minimising Risk webinars, and today we're doing disciplinary hearings. So a warm welcome to you all, and thank you very, very much for joining us today. Just going to start by introducing ourselves, as we always do. So my name's Karen, and I'm the HR Knowledge Manager for HR Solutions, and I'm going to be the lead presenter today. And I'm joined by my colleague Atim, who's here to field any technical problems that there might be. Hopefully, of course, there won't be any, but if you do have any issues at all, please do just use your control panel to drop her a message and she'll see if she can do anything at her end to help you out. Also, as we go along, if you do have any questions, you can also pop those down and send them over to her, and she's just going to collate them and then we'll pass them to me at the end of the webinar, and I'll look to email you back an answer either today or tomorrow or perhaps early next week. So do send them over because we do like to get questions. So yeah, that's what she's going to be doing for us today. We're also recording the session, so you will be able to listen back again and watch it online if you would like to. And equally, if you would like to contact us, if you think that a copy of the slide deck would be helpful to you, please do just let us know and we'll send them over by request. Okay. So this is what we are going to be covering today in our webinar. As I'm sure you can imagine, the topic of disciplinary hearings is vast, really. I could spend days talking about this. So we've only got an hour. And what I've decided to do is focus on some areas that are either often asked about or aren't, but tend to come up as issues, on our help line. So we're going to look at how to draft the perfect allegation, okay, before we've even got into a hearing. Looking at giving notice, the right to be accompanied, who should run the disciplinary hearing, how to structure your questions, and then lastly, I'm going to give you some tips on how to decide what the outcome should be. So hopefully you'll all find that quite useful to you. We've got some aims, so we're going to look at focusing on the areas, as I say, commonly asked about or that are perhaps often not got right, that we need to step in and help with. I'm going to provide you with some tools on how you can get these right, when you're doing it yourselves. And I'm going to look at giving you both some legal and practical applications to understand both why and how certain things should be approached. Sometimes it's no good just being told to do something, is it? We want to know why. So I'm going to try and look at doing that for you as well today. So let's make a start then. We're going to begin with how to draft the perfect allegation, okay? I feel that this is a really important place to start, actually. And the reason for that is, once you've got to the end of a hearing and you're looking at taking action, giving a warning or maybe even dismissing, that disciplinary action can only be taken in respect of allegations that were set out in the disciplinary invite letter, okay, and only in respect of those which are found to be true. So for this reason, allegations must be carefully worded, okay, and ideally there should be an allegation for each matter of concern as well, okay. Now, common problems that come up with allegations is that throughout a hearing or perhaps in the outcome letter, different wording is used to that which is in the allegation, okay? And so some cases fall down because it's not clear what somebody was being disciplined for. So it's extremely important that we do make sure that allegations are carefully worded, because that's the wording we're going to have to stick to. And that wording can't be disproved, in any way, otherwise, that allegation could fall down. So if there are different allegations that we could make, it's important that we separate those out, you know, so you might have one event, but there might be 2 or 3 allegations that could come out of it. It's important we separate those out so that if one did fall down, you know, we can potentially still uphold the other. Okay. Now, in the invite letter, allegations must be clearly set out, okay? And they should state what the employee has done wrong, when this happened, and it should include brief details of what happened as well. It's crucial that an employee is able to understand exactly what they are being accused of, okay? And the reason for that is so that they can fully prepare for the meeting. If they aren't able to fully prepare for what they're being accused of, the entire process is deemed to not be fair, okay? And equally, subsequently, any warnings that's issued will also be found to be unfair. In addition to this then, the allegations must be very clear that they are alleged, okay? There must be no reason at all for the employee to doubt that the matters of concern that are being addressed to them are alleged, as any evidence that the outcome of the hearing is predetermined can seriously undermine the meeting itself, okay? And again, it can even result in the outcome being procedurally unfair. You know, if you sort of indicating that you've already decided this person is guilty, or what warning or dismissal you've decided to issue before the hearing's even taken place or during the middle of the hearing, it just renders the whole thing to be a sham, really. You know, there's no point in going through with it. So we've got to be very careful that we're clear that these matters are alleged until the very end of the hearing, and even then, you know, you've got to adjourn, you've got to have time to consider what's been said in the hearing. So not until the outcome letter is issued should there be any reason given to the employee for them to think we've already decided. So structuring allegations can be difficult, and as I say, it's something that is not usually asked about on the advice line, but when we get disciplinary invite letters through to be reviewed, these are often, you know, the weak areas where we have to spend time putting them right, okay? Now, I'm going to provide you with a formula that I've sort of devised, and maybe I should get copyrighted, I don't know. But I use it myself to write strong allegations, and I'm going to share it with you now to write strong allegations as well. Now, this formula is good if you're writing an allegation about unsatisfactory conduct or misconduct or serious misconduct. It won't do for gross misconduct allegations, okay? If you've got something that's GM, gross misconduct, then they should be a lot meatier, and they should include some additional elements, which we are actually going to be looking at next month, okay? So if you're not signed up already to our gross misconduct session, then do join us. I think it'll be a good one. So I'm going to put the formula up on screen here for you. I'm just going to talk it through then. So it begins with alleged. You can write a disciplinary invite letter and say the following matters of concern are alleged, but for the purposes of giving advice, I think it really helps if we get into the habit of just putting alleged at the start of each matter of concern, because we show that each one of these are absolutely alleged and are not predetermined in any way. Thank you very much. So we'll start with alleged. And then in my first section, so I've separated the sections with those vertical lines, and I've highlighted these options in pink. So in the first section, you would pick either breach of the or failure to, okay? And this section is where you just confirm that something has gone wrong. This person has breached something or they failed to do something. So select whichever is applicable. Then in the second section, or the blue font, okay, you want to identify what rule or expectation it is that hasn't been followed or adhered to, okay? So if in the first section you picked breach of the, you might follow that with state the name of the policy breached. So breach of the social media policy, for example. So you'd pick whichever applies there. And then in the third and the final section where there is orange text, you would identify exactly when and how that happened. Okay, so we're confirming the matter is alleged. We're confirming that something has gone wrong that shouldn't have happened. We're identifying what rule or expectation has not been followed. And lastly, we're identifying when and how that happened. Okay. Now I'm going to give you some worked examples of these by using a scenario. Before I get to that scenario though, I mentioned that it's important to have separate allegations for the different things that have gone wrong. So I'm just going to have a quick look at what I mean by that first, and then our scenario will work through it all. So, when there has been some misconduct, okay, which is serious enough to warrant a disciplinary hearing, the circumstances are usually such that at least 2 separate allegations can be derived from it. Okay, that is usually the case, at least 2. And it is important to distinguish these and to deal with each allegation in turn, because as I said before, by doing that, if one of the allegations should fall down, you know, because you've not got a lack of evidence or because the employee justifies it in some way or counteracts you in some way, then you may still potentially be able to take some form of action based on the other, if that holds up, okay? There's nothing more frustrating than not being able to issue a warning against somebody who's done something really wrong because you've not worded your allegations correctly. So it is important to distinguish them, and the reason why is so that you can move forward still if one of them should fall down. So here's my scenario, okay? You are the manager of a restaurant in this analogy. And it's Monday the 1st of January, it's New Year's Day, and although it's a bank holiday, you contract your staff to work because it's going to be one of the busiest days of your year. Now, one of your waiters who was down to work and was down to start at 7 o'clock in the morning doesn't show up. But they do text you in the afternoon and say that they're really sorry, but they're too ill to come in. So the next day, you have an investigation meeting with them, and actually in that meeting, they admit that they had gotten drunk on New Year's Eve, and they'd gotten themselves into such a state that actually they were far too hungover to come into work the next day, let alone call you at 7 a.m. And in this meeting, they did recall that you have a policy and a procedure that requires staff to call in, not text, to report their absence before their shift starts, not during. Okay. So this is one thing that's happened. Someone's not turned up for work because they were hungover, okay? But you can extract at least 2 allegations from this. And I'm just going to highlight the parts here where I would get the allegations from. So as I said, 2 things that have gone wrong. Firstly, I mean, we've established that we've got a procedure for reporting absence, and this person hasn't followed it, okay? They text you in the afternoon, they did not telephone you before the start of the shift. So firstly, they failed to follow the correct absence reporting procedure. And secondly, they actively didn't ensure that they were fit for work the next day, okay? I mean, we're not really concerned about the fact that they went and got drunk the night before. They're entitled to do what they want in their own time. The bit we're concerned with is the fact that they put themselves into a state which meant they weren't able to adhere to their contract. They weren't able to come into work when they were required to. Okay. So these are where I'm going to get 2 allegations from. And I'm going to show you now how we would create those by using that formula. So I'm just going to pop this up on the screen. I've just highlighted in pink the parts that I'm using for this first allegation. So this is the fact that they didn't follow the correct procedure. So we start off with alleged, and then I've taken from the first section failure to, and then from the second section I've used the procedure, the name of the procedure that they've not followed. So failure to follow the correct absence reporting procedure. Okay, semicolon, specifically, and now we're going to confirm the when and the how. On Monday the 1st of Jan, you did not telephone to report your absence before the start of your shift as required. Okay, so you end up with quite a neat, about 2 lines long sentence that forms your allegation. You're confirming it's alleged, you're confirming something's gone wrong, the rule that was not followed, and how and when they didn't follow it. Okay. And you'll see that my last section there is quite factual. I'm not really embellishing, I'm not giving anything that could be an opinion. It's kept quite factual because it's just less room for error, less room for someone to argue that you're alleging they've done something that they haven't done. Okay, stick to the facts as much as possible. And then I'm going to work through that second one. Okay, so we've got alleged again, and I've taken failure to. And then from the second section, I've used the option of a management expectation. Okay, it is reasonable for you as somebody's manager to expect somebody to take reasonable steps to ensure they're fit to work. Okay, and that includes not getting drunk immediately before you're supposed to start work first thing in the morning. Okay, so alleged failure to take reasonable steps to ensure your fitness for work. Specifically, and I've added here that they'd admitted it before just to help reinforce that. In the investigation meeting, you admitted that, and I'm putting the date in, on or around Sunday the 31st of December. I've put on or around because it could have still been early hours on Monday, but we'll just allow for that there. You became intoxicated to the extent that you were unable to attend work the next day. Okay. So I've kept it quite factual. Again, I've used the word intoxicated just because I've had cases where actually somebody argues that they weren't drunk, they've been on drugs, you know, they were high or something like that, and you don't want your allegation to fall down on a technicality again. So either way, you were intoxicated to the point that you couldn't come into work. Okay. So, hopefully you like that. I hope you find it helpful, and you can see how I've created those allegations, and that will generate really strong allegations for you that it's very difficult for an employee to argue against, you know, especially if you've done the legwork in your investigation and really established the facts of the case, and that's helped you to write these allegations. And, you know, there really is no ambiguity in them. So again, it's very difficult for an employee to argue they didn't know what they were going to be accused of. They didn't know what to prepare themselves for in the disciplinary hearing. And that's that. Which means we're going to move on then now to giving notice. It's a common question. How much notice do we need to give? You know, I'm just going to explain why. So it is a requirement that employees are given written notice of a disciplinary hearing. Okay, it's a key reason for the disciplinary invite letter. Now, how much to give? That's usually the common question that we get, and to be honest, there's no straightforward answer, which is quite common in HR, I'm afraid. But there are various things to consider when deciding how much notice is appropriate and what the right answer should be. So firstly, we would look at what the legal minimum is, okay, if there is one. We're going to look at the ACAS code and what that says. Another source of information is a disciplinary policy. Most employers have a disciplinary policy these days, and we should also consider any custom and practice that there is, okay? So I'm going to look at each of these in a little bit more detail, but ultimately, whichever of these generates the highest answer is going to be the safest amount of notice that you should give, okay? Because then they can't argue that they're at a detriment compared to what was required or compared to what anyone else might have been given in the past. So let's have a look at these. Before we do though, I'm going to invite you to take part in my poll. So if you've been on a webinar where I've done one of these before, I've just started playing with these really, to be honest. It's just a bit of fun. I cannot see who answers what, and you won't be able to see who has answered what. But it's just interesting and a bit of fun, as I say, to gauge awareness. So I mentioned the ACAS code on the previous slide, and it's something that we're going to mention a few more times in this webinar. So I just want to see what you think to this. What is the penalty for not following the ACAS code of conduct? Okay. What is the penalty for not following the ACAS code of conduct? Now, I'm just going to put some possible answers up on the screen for you. And as I say, I can't see what you answer and nobody else will be able to either. It's just for fun. So I'm going to launch that now. So hopefully you can see three possible options. So if you just select one, there's a 25% uplift to an award issued in tribunal. You've got, it's a trick question, Karen. We've listened to you before. There is no penalty as it's not the law. Or is it up to a week's pay? So I'm just going to give you a few more seconds to have a think about that. I think we've got most people answered. Okay, I'll just give you 10 more seconds. Oh, it keeps changing. All right, great. Okay, I'm just going to close that now, so you have to stick with your answers. And I'll just pop them up on the screen for us all to have a little look at. Right, okay, interesting. So we have got 37% of you who have ticked, you think it's a 25% uplift to an award issued in a tribunal. 57% of you think, yep, here she goes. It's not the law, so there can't be a penalty. It's a trick question. And 7% of you have gone with up to a week's pay. So most answers around the first two. Let's just hide that and then have a little look at what the answer was. So you should be able to see the normal screen now. Drum roll, please. Just in your own head, I've not got a drum here. The answer is 25% uplift to an award issued in tribunal. Okay, so yeah, I think that poll's quite interesting actually. I'm afraid if you thought I was tricking you, I wasn't pulling your leg on this one. So yeah, there is sound reason to thinking about what the ACAS code says and bearing that in mind when you're deciding how to approach a situation. Okay. So this would only, affect you if you ended up in tribunal and if somebody was successful in bringing a claim against you, okay? The employment judge would then, when they're looking at costs and assigning the award, they would look at the ACAS code, think about which parts of the code you haven't followed, and where you haven't followed it, they could potentially uplift the award they decided to give by 25% just because you hadn't followed that code, even though it's not law, Okay, it isn't law. That was true, but they still have that ability. So yeah, there we are. I perhaps so. And this is interesting. Equally, if your employee didn't follow the code, and again they were successful and had an award given to them, if the judge felt that actually they'd been unreasonable in how they'd interacted with you and they hadn't followed the code themselves, then their award can also be decreased by 25%. So it might be some relief that it works both ways. All right, so let's crack on then with giving notice. So I said the first port of call then is, what does the law say? There's actually nothing specific written into the law about how much notice has to be given ahead of a disciplinary hearing. But what it does say is that the notice must be reasonable. That old chestnut. So it's generally become accepted in HR practice that 24 hours is the minimum notice you can give. Okay, anything less than that just does not appear to ever be deemed reasonable in employment law or case law. Okay. We then have the ACAS code to consider. Now, again, this doesn't actually specify an amount of time, but it goes one step further than the wording of the law, so it's worth bearing in mind. Okay. What it says is that a hearing should be held without unreasonable delay, whilst allowing time for the employee to prepare their case. Okay, so what the code requires us to do is to balance not faffing around, not spending loads of time collecting evidence. It's got to be a priority. We've got to be snappy in getting it together and arranging that hearing. But also we've got to consider, the complexity of the issues, the circumstances going on, and determine a reasonable amount of time for the employee to get ready to defend themselves against all that. Okay. And so it's for this reason that it's generally become practice. Most HR advisors and that will tell you that you should give a minimum of 48 hours notice, and this is where we get that from. Okay, we tend to advise a bare minimum, and it is a minimum. We can't stress that enough, really, of 24 hours for very straightforward cases where there's very little evidence and it's an open and shut case, and a bare minimum of 48 hours for anything that's a step up from that. Okay, anything less is likely to be deemed unreasonable. Then I said that we have disciplinary policies to check. It's no good breaking your own rules, so if you do have a disciplinary policy, please open it up. Don't leave it to get dusty on a shelf. Have a look and see what it says, because if that states the minimum amount of time for notice, you want to comply with that, especially if you are a larger organisation. Okay, and you've got various managers who could be conducting disciplinary hearings, across the country, let's say. Your policy is what's going to keep you all consistent, because if a person in Southampton, is going to be treated differently to a person, in Crewe, that can still be unfair, if they did the same thing. So you want to make sure that you are adhering to your policy, just for consistency reasons, so employees can't argue they're being treated unfairly or, worst case, discriminatory. And if your policy is contractual and you don't adhere to it, then you're risking a breach of contract claim as well. And then lastly, we've got custom and practice. So similar to the reasons why you should follow a policy if you have one, it might be that you disregard your policy, or you just kind of wing it, and that's fine. But bear in mind how you've treated somebody recently. So if you've disciplined anybody recently, consider how much notice you gave them and do the same thing here. Unless there were any extenuating circumstances, of course. And again, the reason is just so that you can make sure people are treated fairly. They can't argue they've been treated differently for discriminatory reasons. It can even become an implied term. You know, people have always been given 5 days notice of a disciplinary hearing, and suddenly you're giving me 2, and I think it's because you want me out the door. You know, it's a very easy argument to make just because you've not been consistent. So always bear that in mind. So those factors aside, sometimes it's reasonable to give even more notice than what those things might have determined. And factors that might contribute to that include the following. So it could be that actually it would be a reasonable adjustment to give more time to prepare. And I'm using the phrasing reasonable adjustment because I'm referring to the Equality Act. Okay, so if somebody perhaps has profound learning difficulties, they might be at a detriment, you know, in preparing for their case within 48 hours compared to somebody who doesn't. Okay. You might also have sickness or other absences going on in your organisation that mean it's not fair to go steaming ahead with the disciplinary as quickly as you might have done otherwise. And sometimes you might even have, you know, the involvement of the police who will tell you that you're not allowed to proceed with your processes and investigations, and there could be other serious factors going on as well. So often we get asked, when does the notice actually start, from some more savvy clients asking the question, because it's often taken for granted that you pop it in the post and that's it. Well, no, notice starts at the point the employee receives the invite letter, okay? So please remember to take that into account, especially if you're posting it, because you'll need to take into account postage times if you're not hand delivering the letter. So notice begins to run at the point at which the employee receives the invite. Okay. So it can be handy to get a signature that someone's received it. But if you are using the post, you know, it's typically accepted in tribunals that a letter sent by first class and recorded will take 2 days to get to the individual, excluding Sundays and bank holidays. Okay. And case law does tell us that it's deemed reasonable for us to assume a letter would have been received if you've sent 2 copies, one by first class post and one by next day delivery. Okay, signed for. So if you've sent 2, one by first class and one next day signed for, it's reasonable for you to assume that they got it, even if you don't hear from them. Okay. There we are. And it's getting more and more common, you know, that actually we're just sending the letters by email these days, which is absolutely fine. Not got an issue with that. What I would say, though, is that care really ought to be taken, firstly, just to ensure that that email account is private to them, that the address is correct, you know, and that you've got good reason to believe that they are actually monitoring that account regularly. It's not just one they've put on their new starter form, you know, 3 or 4 years ago and they never ever use it. It wants to be an account that they've emailed you from recently in the past, so that, again, you can show I had every reason to think that they would get that. And me being me, I'd still just pop a copy in the post anyway. So that's notice. I hope that's clarified a few things. We're going to move on then now to the right to be accompanied. And this is bringing me to a second poll. It's our second and last poll today. So here's the question. Who can accompany an employee under the statutory right to be accompanied? Okay, so the statutory right to be accompanied is asserted by your employee. Who are they allowed to have come with them? Now, I'm going to launch answers. Now, you can tick as many as you think are correct, okay? Not all of them are. So, Do you think that they could be accompanied by a trade union official or rep? Do you think they can be accompanied by a parent or guardian if the employee is under 18? Can they be accompanied by a fellow colleague, a solicitor, or can they be accompanied by an ex-colleague? So you can select as many as you think are correct. And I'll just give you about 10 more seconds to do that. Okay, I've nearly got everybody, so just give you a few more seconds if you want to get your vote in. Okay, great. I'm just going to close that now. Lovely, thank you. So let's have a look at what we've got. Interesting, right, okay, lovely. So 97% of you think a trade union official or rep can attend. 76% think a parent or guardian can attend if the employee is under 18. We've got 94% saying a fellow colleague, 24 a solicitor, and 24 an ex-colleague. So we've got really heavy focus on the first and third one, quite a lot on the second as well, and then kind of split people perhaps on the last two there. It's great. So I'm just going to hide those now. So hopefully you should see the question that was asked originally. I'm going to move on then now to just reveal the answer. So there were two correct answers, okay? The first one is a trade union official or rep, so congratulations. I think pretty much everybody got that. And the last one is a fellow colleague. So again, we nearly got 100% on that one as well. So that's really great, everyone. That's really good. To the others, I've kind of probably given you some red herrings in there, and they're ones that are often assumed, you know, so I wouldn't feel bad. You're probably still in with a lot of people there who think that the others are part of the statutory right. A parent or guardian, if the employee is under 18, that is not actually part of the statutory right. It's something that would fall more under the umbrella of a reasonable adjustment. So we're talking the Equality Act and we're talking age. You know, is it reasonable to allow someone under the age of 18 to be disciplined on their own without a parent or guardian? Perhaps not, but perhaps it is. You know, it really depends on the circumstances. You do not have to allow a solicitor to attend, and in fact I wouldn't, because they normally just get in your way and make it more difficult, and you don't have to allow an ex-colleague either, just a current colleague. So let's review this right then. So it is the statutory right we're talking about here, and they have the right to be accompanied at a disciplinary hearing, so not the investigation, just the disciplinary hearing. And they only legally have to be accompanied by a fellow colleague or a trade union rep or official under this statutory right of accompaniment. Now, ACAS creep up again here. Although it's not a legal requirement, so it's not written into law, the ACAS code does state that employees should be advised of their right to be accompanied at a hearing, okay, in the disciplinary invite letter. It's considered to be reasonable. It allows time for arrangements to be made ahead of the meeting. And as I've said, failure to do that could potentially result in a 25% uplift to any awarding tribunal. So if an employee asserts this right, okay, regardless of whether you decided to tell them about it or not, it must be allowed, okay? Failing to allow them to do that could be a breach of their statutory rights. It could render the disciplinary procedure and any subsequent outcome as being unfair. And if if you were to take any punitive measures against the employee, and that could include, you know, a rash decision to dismiss because you might feel frustrated, they're delaying the process, just trying to bring somebody in, even though it's an open and shut case. You might have only given them a written or final written before. You know, if it's possible to link any punitive measures to them because they asserted that right, then that can give rise to an automatic unfair dismissal claim, okay, which has an uncapped award. So do not appear to take any punitive measures because they asserted the right, only because of the matters of misconduct that you are alleging against them. Now, if the chosen companion cannot attend on the proposed day of the meeting, then you must allow the hearing to be postponed, okay, and you must rearrange it within 5 working days of the original date of the hearing, okay. So I should probably be careful about how I word this. If they can't attend on the original date of the hearing, okay, they can say to you, we need you to rearrange it, and that's fine, okay, but you only have to rearrange it within 5 days of the original date of the hearing. If they say to you, well, actually, I can't attend within those 5 days, you're at liberty to say, well, that's tough. I'm going to go ahead with the original date of the hearing then, okay. But if you don't allow that time for the postponement within the 5 days, then again, that is also a breach of statutory rights. But I have to put up a little warning sign here because of something that happened very recently. And I'm going to share with you this case that only came out in August this year. Okay, so in August 2018, in this case of Talon Engineering versus Smith, the circumstances were that there have been numerous delays in the process due to sickness absence, annual leave of staff and things like that. And throughout the process, this employee had intended for their trade union rep to accompany them at the disciplinary hearing. Okay. When they received the invite, the rep said that they were not able to attend within well, at the original time, and they couldn't attend within 5 days either. So, you know, based on the advice that I'd just given about the statutory right, the employer said, well, you know, I'm sorry, you can't attend within those 5 days. We're going to go ahead with the meeting, okay? This process needs to be got done. It's been delayed, you know, for various reasons, and we need to bring this to a head. You know, we can't unreasonably delay it anymore. Now, even though they complied, the employer complied with the statutory right correctly, the appeal tribunal ruled in August that this decision was actually unfair. And the reason is because the employee's legal representative was quite savvy, okay? They did not bring a claim for a breach of statutory rights. They brought a claim for a lack of fairness under what's called Section 98 of the Employment Rights Act, okay? And they argued that in the circumstances of the case, it was unfair not to have allowed a slightly longer delay. I think the TU rep could come within sort of 8 days or something, because of all the delays that had gone on so far, and that a reasonable employer would not refuse such an important right to an employee for the sake of a few extra days, and they won. Okay, so it's very important that despite anything you might learn about the statutory rights or any other statutory rights, that you always consider the fairness of the circumstances as a whole. Okay, so yeah, I was quite shocked when that came up. Yeah. Oh, tidbit for you as well. Did you know an employee doesn't always have to be a member of a union for them to be accompanied by a rep? Sometimes they will accompany people who aren't in their union. So there we are. So beyond the parameters of that statutory right as it's written into law, some employers may well have in their disciplinary policy that you can be accompanied by other people, such as a family member, such as a solicitor. Alternatively, I've mentioned custom and practice before, and it really is something you ought to bear in mind so that people can't argue that fairness aspect again. But if you have allowed people to be accompanied by others in the past, just because you were nice, you've probably got to allow it again. And equally, as per my sort of red herring in the poll before, it could be a reasonable adjustment to make for an employee, okay? If someone perhaps needs a translator because they're from a different country, or if they are young and perhaps not very worldly minded, and you think that they could do with being accompanied by a parent or guardian, some people, of course, they're old enough to be employed, they're perhaps old enough to go into a disciplinary hearing themselves to answer for their conduct, but sometimes it might be reasonable if asked for, to allow a parent or guardian there, or even just to offer it so you can show your reasonableness. All right. So, who should run the meeting? Well, when considering who needs to run the meeting, there are a few pointers to bear in mind, which will help you to select the right person. And these are as follows. So ACAS comes up again. Whoever it is should be different to the individual who ran the investigation meeting as far as possible. Okay. They should also not be involved in the matters at hand in any way which might prejudice the process, okay? So they shouldn't be a witness, okay? Your witness and the people who are running the process should all be different people. Equally, if there's possibility that they could have some sort of contributory fault, have they not done something which meant that something else happened, which is why disciplining the employee, you don't want them involved in the process if that's the case. It sounds obvious, but sometimes it's missed and people kick themselves at the end. But if your policy states that certain roles only have the authority to dismiss, and you think that disciplinary might end in dismissal, you want to make sure that the person who is making the decision has that authority to make that decision. And bear in mind that if an appeal is received, then akin to the first one, somebody else needs to hear that. And I'd say this about the first one as well. This person should ideally be of equal seniority or higher to the person who did the previous stage. And that is to avoid any bias. You don't want people to be put in a position where they have to go against what their manager, or their superior has said. Policies, again, check your policy. Don't be in breach of your own rules. There's nothing more embarrassing than that. If there is a policy in place which states who must hold it, then that's got to be complied with. And if you've still got a handful of people to choose from, then I would suggest you perhaps look for people with soft skills, such as someone who's got an objective approach, someone who's able to make very balanced decisions, someone who's fair and reasonable. You don't want someone who's quite bloodthirsty, storming in and asserting themselves. It's just not helpful at all. Someone who is willing to take responsibility for their decisions. If you're chairing the meeting, the outcome is your decision. You can't backtrack in the future and say, I don't know why I reached that conclusion, or I reached that conclusion because he or she told me to. That will not do at all in tribunal. You want someone who is inquisitive and who's going to seek to understand the reasons why someone's conducted themselves in the way that they have done. You want someone who can communicate clearly, both in writing and in speaking, because you don't want ambiguity. And it sounds basic, but you want someone who's just got the time, who's not time pressured. I mean, who isn't these days? But you want to, support that person with clearing their schedule so that they are not going to be rushed and they're going to give due care and attention to the matters. Again, it just helps to avoid anyone forming preconceived ideas and jumping to conclusions. Okay. Next up then, Structuring questions. So I'm just going to pause for a moment here. So you should just be able to see a picture of a jigsaw with a missing piece. I'm just going to talk at you for a while so you listen to me. We don't often get asked about how to structure questions on our advice line at HR Solutions, but it is often something that we pick up as a common area for pitfalls. I don't know why it is. I'm not sure if it's because people just aren't used to doing them. You know, hopefully no one likes doing disciplinaries, so you don't do that many. Sometimes people often think that, you know, things have been established in the investigation, so we don't have to repeat what we've already established here, you know, and I can see the logic and the reasons behind that, but it's so important to spend time preparing questions, okay? It saves a lot of time in the long run, and it just makes for a much more productive and meaningful conversation. Sometimes disciplinary minutes are reviewed and we can see that there are still unanswered questions, there are still facts that have not been clarified or addressed, and they could have been in the original meeting, but now a further meeting has to be arranged, you know, and the process just becomes drawn out and protracted and distressing, you know, for everyone involved. The employee, you know, can lead to time off with work-related stress, and then you've got sickness absence to wait for and to even deal with. It might even result in a medical capability process, you know, sick notes, medical reports, occupational health, you know, just a protracted and ill-structured disciplinary can just generate so many further delays and complications. So I can't stress enough the importance of just spending some time thinking about your questions. I mentioned, you know, this idea that, you know, something's been established in the investigation, so, you know, why do we have to repeat ourselves again in a disciplinary hearing? And that often comes up, but it's really important to do that. And it might feel like a repetitive exercise, but I'll tell you why it's important. And somebody I worked with a long time ago told me this analogy, and it's always stuck with me. It's a bit crude and graphic, to be honest, but I'm going to share it with you. Hopefully you find it helps. If you're watching a TV program or you're watching a drama, you know, like a police detective drama, and it cuts to a scene where somebody's walked into a room, there's a dead body on the ground, covered in blood, and somebody has stood over that body with a knife in their hands, covered in blood, okay? The next scene is not them in court stood in front of a judge. You know, the next scene is probably them being carted off to the police station and sat down and asked, you know, questions. What's gone on? Why were you there? Why are you stood in that room? You know, and you give that person a chance to give you an explanation, even though you think what you've seen is very black and white, you know, and clear cut. And although not quite as extreme, hopefully, it's the same principle here, okay? Your investigation meeting is you giving that person an opportunity to informally say, whoa, 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 it wasn't me, or whoa, 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 there's a good explanation. I just found them here like that, you know, I'm trying to help. You're the second person in the room, you know, and you try and establish whether or not that's plausible. And then your disciplinary hearing is the formal setting. So if they didn't give you a good explanation, your disciplinary hearing is where you recover that ground, you re-establish the facts in your minutes, and you get to the bottom of the situation then, and it's like the being in court bit, if you like. So it is important to re-go over that, because it's only based on what's happened really in your disciplinary minutes is what you can really uphold your allegations on. Okay. So I'm going to stop rambling now and get on with some advice. So I would suggest you approach your preparations by reviewing the investigation first and just identify the point at which the misconduct occurred, okay? Now, it's most likely going to be the circumstances that immediately led up to and immediately followed this point that will be the focus of your questioning, okay? Now, the reason for that is, you know, usually At any point up until the misconduct happened, that employee could have chosen to act in a different way. Okay, but they didn't. So why didn't they? And equally, you know, the time after can be quite important as well, because it shows their motivation and it shows their outlook. You know, did they try and contact somebody straight away and let you know what happened, you know, or did they try and cover it up even? You know, why have they behaved and done what they've done immediately around everything that went wrong? Now, you know, I always think it's important that we set out trying to see that someone's done the best they could in a situation, but it, you know, it's rare, but it can be that, in fact, what happened, even though it's misconduct, it could have been the lesser of two evils in an impossible situation, you know. So we really need to try and establish that, because it might have a bearing on the outcome. Now, you don't have to do this, but just like my formula for an allegation, I tend to advise and follow myself a three-pronged structure to questions, okay? And I would take these 3 steps in respect of each allegation in turn. So, you know, I'd read out my first allegation and I'd start by trying to establish, 1, do you know the rule? 2, why did you not follow the rule on this occasion? And 3, do you understand why that is not acceptable? Okay, it's no good for an employee not to understand why their behaviour was unacceptable, because it means that they may well repeat that behaviour in the future, and they're also just more likely to appeal. Okay, I don't think I did wrong. I don't think this is fair. I'm going to stick my appeal in. So yeah, it also just makes for any subsequent warning to be much stronger as well, okay, because you can show that you're not teaching the employee to do something in this process. They already knew, and they already knew better. So you'd got your precautions in place to keep them on the straight and narrow, and they fell foul of that. Now, each of these will invariably lead to further questions, and that's fine. And in fact, it should do that, and those questions are going to be unique to the circumstances of the case, and there's going to be where you establish your facts around what happened, okay, but they should ultimately lead back to answering one of these 3. So, you know, if you've ever done them before, it can be easy to get lost in a hearing. You know, there's so much back and forth. You're trying to think about what someone's just said to you, and there's nothing worse than coming out and thinking, oh, I've not asked that. How am I going to establish this? You know, am I going to have a further meeting with them? But if you just give yourself a few minutes just to think about what they've said and just draw your pen back and think, right, have I answered number 1? Do you know the rule? Have I answered number 2? Have I established that they understand why it's not acceptable? You know, then move on to the next allegation. And so now, last but not least, some tips on deciding the outcome. So let's just have a quick think about what possible outcomes are, because it's best to know where we're going before we decide on the route there. So I've graded these out because it shouldn't really be that we get as far as a disciplinary hearing and issue an informal warning, but don't let it go too far. Don't do it just to save face. You know, if you get into that hearing and you think this should never have got that far, you know, go back and issue an informal warning. But you could potentially give one of these no further action. You might just have a documented discussion, or you could even issue an informal letter of concern. It can still be quite a formal and strongly worded letter. You might just identify how you want them to improve in the future, but it sits outside of a disciplinary process. And then the formal warnings, okay? So I've grayed out a verbal warning because they're generally just not recognised that much anymore. You know, they're still in some disciplinary policies, but generally it's not considered worth the time and effort to go through a hearing just to issue a verbal warning. They used to just be on file for 3 months or so, and there's not a lot of value in that because they expire too quickly, you know, for you to do anything with if someone repeats offence. But otherwise then, you could end up on a written warning, a final or a first and final written warning if it's serious enough, a dismissal with notice, or a dismissal without notice. So the latter is something that you would only ever do in a case of gross misconduct. Another possible outcome is demotion, but that would only be a response where the alternative is a fair dismissal. Now, conscious I'm towards the end of my hour, but I'm going to just go through these quickly. So it goes without saying, you know, every case is always unique, but thankfully there are certain things that must always be considered before deciding on an outcome. Okay. Firstly, can you form a reasonable belief? Okay. Now, reasonable belief is a terminology for employment law as opposed to reasonable doubt, which is criminal law. Reasonable belief is much easier to achieve. Nobody expects us, you know, business owners and people doing other things otherwise to be experts in investigations. But have you extracted yourself? Have you been able to form an objective decision about what happened, you know, based on your awareness of the circumstances and your interpretation of all the relevant facts that you could reasonably obtain at the time? Have you checked your disciplinary procedure? Because again, that is a source of information that may well give examples of what type of conduct attracts what level of warning. So that's a good place to start as well. You might also have other policies that are relevant to the case. So again, if you did have somebody who was abusing their email or abusing the use of the internet, and you've got a relevant policy, refer to that, because it may also well suggest whether or not that would be regarded as serious misconduct or just misconduct. If the employee has got existing live warnings on their record, okay, then that may well push up the severity level of the warning that you are going to otherwise issue. Consistency, again, you just cannot get away from that in HR. Consider what other people have done in similar situations and what level of warning they were issued, okay, and issue the same. Or if something is significantly different, you know, just make a note for yourself why you would justify giving a slightly different warning in one situation compared to another. And it's got to be objective, you know. Other employees who are involved, so if, you know, a group of people have all been involved in the same thing, it's likely that they will all have to end up on the same warning, okay? Equally, between them, they might have done something which means there's a significant difference, and that might have to be reflected in the level of warning that they achieve. So again, make a note of the objective reasons why that might be. Okay. Consider any mitigation. Okay, so again, you know, you've thought about what level of warning the policy says or what you've issued in the past, but do they have any mitigation? Is there any explanation that justifies the conduct at all? Are there any damaging side effects? You know, had their intention been good the whole time or not? And consider whether or not this should impact on the severity of the outcome. And remember, whatever you do, please do not announce an outcome in the meeting. Okay, that is a surefire way of providing evidence to the employee that the whole thing was predetermined. Okay, even if you think you've sat and listened to it all, that is just not going to do. You've scuppered yourself. Okay, you need to adjourn the meeting and you need to consider what has been said, and it may well be that you give the outcome a few days later, but far rather you do that than sit there at the end of the meeting and say, right, this is what we're going to do. Okay, and that is the end of our webinar today. I hope you enjoyed it. I hope you've found some useful tips in there. We've got some HR events coming up, which I shall be attending, and they're always really good fun. We have plenty to eat. So if you'd like to come along, have a look at the dates there and the locations and join us. It would be a pleasure to see you, and we can have chats through in depth about anything we've ever discussed in the webinars or any other issues that you might have, specific to HR and employment law, of course. All right, thank you so much. We said at the start that if you have any questions, you can pop them through. Please do. Now's your opportunity. I'll be very happy to receive them. And I think you usually get a follow-up email as well, which just reminds you of my address. So you can always pop them over there too. that just leaves me to say thank you once again. Take care, and I hope you will join us for another webinar soon. All the best.